Okay, thank you. Welcome again. Today we continue with our next topic under the course Criminal Law 100. Criminal Law 100 is what I personally coined as myself as for myself as a code intended mainly to serve as an introduction to criminal law. So in this particular section of the criminal law class, it's intended to expose the students, followers, practitioners with the basic concepts and principles of criminal law. That has to do with uh, for you to know what are the principles of criminal law that the law operates on. Generally, if you check out what the word they have, almost most of the countries they apply the same very principles. Generally, except that when it comes to criminal code, the specific acts constituting crime that has to do with the criminalization of behavior as a crime is left with the norms and values of that particular country. But generally, all of them follow the same principles and concepts. You take it even at the international level, it's the same. So today we like to continue with the topic, the general principles of criminal law. These are the principles that regulate criminal proceedings. Don't just see them being listed there, but they have a lot of interpretations and meaning, in other words. And also the way they apply particular nations or nations all over the world, apply them in the area of criminal law. Criminal law is guided by these principles. So for the major principles, for the benefit of this class, we will try to deal with these particular concepts as they are. The first general principle of criminal law is nullum crimen sine lege. Nullum crimen sine lege. Is if you check the Black's Law Dictionary, it will tell you that the meaning of the Latin clause or principle is that it is saying to you, all over the world, in many criminal jurisdictions, there must be a law to define an act. But before I proceed further, let me just try to correct some things. Somebody was posting, asking, criminal custom, the different, it said customary law and this is different from criminal law. And I think maybe it was an understanding of context. When we say the sources of criminal law, we are seeing over the years how the penal law developed. Those days, laws were not written. The first institution or society that began the process of codification, it was during the Babylonian Empire. It was the Babylonian Empire that decided at the time for the formal codification of norms to call them as codes. And during that period, those who were more educated and exposed to life and society in terms of the norms and values of society, I mean the educated ones, received harsher punishments then the uneducated, the lay people who were not informed or educated of the law. But those days, the laws, in many cases, the laws were people, the law was the king. The king defines what the law is. So the king defines your violation. As time went by in Great Britain, it started to develop into codification. Let's write the norms. Let's write them. But those days, the criminal law was only based on customs. It was not based on writing it as a code. So people started demanding and said, look, but it's only the educated who are aware of certain rules. The poor man is not educated. The rules are not made public for people to understand. So let the rules be codified, that people must be aware of what is expected of them, so that when they are acting in society, they can be acting in an environment that they're not aware of what the rules are. So they decided to codify specific norms as violations of the law. That form of codification became the criminal code. So when you hear we say the source, one of the sources of the criminal law or the penal law is that it developed from that kind of practice. So criminal law developed from these norms of society that later society demanded that they should be codified. And that is why we say criminal law, one of the sources of criminal law, is customary law. You find that even in international criminal law, one of the sources of international criminal law in the international criminal justice system is customary law, customary international law. Rules and customs that the international system of the world decide to be violations against the acceptable norms of the international community were codified into what we call the Rome Statute today in The Hague. So whenever you are accused of violation of international law, especially at the level of the ICC, they use the Rome Statute. Then they look at conventions. Then they look at also the Security Council decisions promulgating that specific acts are in violation of international human rights. So international criminal law sources come from that particular perspective. So that's why you call international norms. Those that in the international system, there were no unified, contemporary written code that defined until the UN started doing that. So it came from international customs. That is the same with national code, criminal codes. The penal laws that are written in many of the states, they develop from the customs of those states. Are one of the sources. That's why. So somebody was raising some concern, and then they posted the article. They said the travel law of Liberia. Yes, the Liberian penal law developed from that. Also, that's what we mean by sources. Some of the sources of criminal law. But let's come to the general principles of criminal law. Nolum crimen sine legis. In criminal law, there is one of the major principles of criminal law is there is no crime without a criminal law defining that act as a crime. No human behavior is considered criminal except there is a penal law that defines that particular behavior or act as a crime. So in Latin, because most of the principles of law develop from the Latin doctrines of practice. That's why you see in the legal profession, they get a lot of Latin clauses, phrases, principles of law. So in Latin, it's called nolum crimen sine legis, sine legiam. No crime without a law. That means no act, no human behavior is considered criminal except there is a criminal law that defines that act as a crime. And who passes that law is the host of legislature. So in Liberia, it is our legislature that writes the bill into law. And whenever it is passed by the both houses, meaning the House of Representatives and the House of Senate, it is sent to the president. The president signs that particular law, and then the major requirement of that law to become binding is that it is published into handbill. So the Minister of Foreign Affairs published the act into handbill as the subsequent required act to constitute the act being, they constitute the bill that is passed to be a law. Now, once that is done, like we have our penal law in Liberia, the criminal law of Liberia. So now we call it the new penal law as it is captioned. That new penal law, no one can be prosecuted in Liberia for any act in that new penal law does not spell out that act as a crime. That is why in the criminal justice class the last time I told you that when the writ of arrest is issued by a court of competent jurisdiction, meaning the court that has the authority to issue the writ must state the specific provision of the criminal law or law that the person have violated. That is a cardinal principle of law. It is because of this doctrine, nullum crimen sin legis, no crime without a law. There can be no behavior that is defined as a crime in Liberia which is not spelled out in our penal law. If our criminal law does not identify the act as a crime, it's not a crime. So if somebody tells you violated the law and the penal law does not spell out the crime, you have the right to question it. Or another law that defines it to be a crime and can be prosecuted under the penal law. If there is no law that states that, then you have the right to move to strike the writ. Ask the judge to dismiss the writ. That it is of no legal effect. The next principle of criminal law that you need to know as a student of criminal justice or as a student of criminal law or as a student of law is nullum pionam sin legis. Nullum pionam sin legis is a legal doctrine with its derivative, which derivative is from the Latin language. It comes from the Latin language that says, if the criminal law defines an act as a crime, that very criminal law also must define the punishment for the act. These are the two major principles of criminal law. They are the two most powerful principles of criminal law. Nullum pionam. Nulla pionam sin legis. No punishment without a law. You cannot punish anybody for any violation as a crime in the context of the criminal law or our criminal jurisprudence when the penal law does not define the punishment for that act. Because the purpose of the criminal law is to punish. So if the criminal law does not sanction punishment, then it is not a crime. And so what are the principles of punishment? What are those principles of punishment? What are punishments? What are the punishments? When you see suspension is punishment. So that's why there's an argument. A man is suspended from office because he had committed an offense. So when you use the word suspend for this allegation, then the question of the legitimacy of the suspension in terms of due process of law becomes a serious concern. Suspension. You find a man, you are fined, is punishment. You are suspended for 1 week off the job, is punishment. You are hereby warned, is punishment. That's why if you check most of the, for many of you who are working in the United Nations system or the international system, your boss cannot just write a warning letter addressed to you without a hearing. Because in the United Nations system, I remember my years when I worked there as a consultant, your boss cannot write a complaint against you, and there is not a committee to investigate the violations that have been alleged, and they put it in your file. No. There must be a hearing in the system. When they find you that you are liable, then the punishment spelled out for that, with that warning, for instance, then they will write you the warning, they put it in your file. The HR. That is how they do. But for people to say you can punish the person and then you suspended 3 months off the job pending investigation. In my view, as a legal practitioner, it's a violation of due process of law. Because our Supreme Court of Liberia, over the years and again, in fact, the first one is Wallow versus Wallow, the landmark case handled by the Honorable the Supreme Court of the Republic of Liberia. The Supreme Court said, they said due process is the law of the land. Due process is the law that must hear before it convicts or condemns. You can never condemn anybody when there is no opportunity for that person to be heard, to hear his side of the case, to cross-examine the people accusing, even in the administrative system or any ministry or agency or bureau or institution or private institution. You must have a hearing. The person must have the opportunity to produce evidence in his favor. He must have the opportunity to cross-examine the witnesses you brought against him, and then he must have the right to a fair hearing. Fair hearing. And then you can punish him. So, in our criminal law, the criminal law says there is no punishment without a law. So before you punish a person, the criminal law says there must be a law defining the punishment for that particular act, as well as defining that that act is a crime. When you go into the Rome Statute of the International Criminal Court, for those of you who have interest in studying international criminal law, these principles are in fact enshrined in the Rome Statute, the law that the RCC normally uses to hold people accountable for violations of international human rights law, international humanitarian law, or international criminal law. You will see these two principles also there. The third principle that we need to deal with today is the non-retroactivity, rational personae. The non-retroactivity, rational personae, I won't be saying it fast, is the doctrine in criminal law that says the act, let me just make it simple, the act that was not defined yesterday as a crime in our penal law and people were committing or carrying out. If we made a law today and consider that particular act as a crime today, the only people that can be punished for that act that we made today will be the people who committed the act today after the passage of the law and onward. But those who committed the act yesterday, that is now defined today as a crime, but it was not defined as a crime that period, it cannot apply to them. Sometimes we can call it, sometimes most of Liberian lawyers will call it the doctrine of retroactivity. Ex post facto law. You cannot punish a person for an act that was not considered as a crime yesterday or during the time they committed, because you'll be retroacting the law. So is the case with, let me give you another example. So is the case with the International Criminal Court, the International Criminal Code, the Rome Statute of 2002. The RCC Rome Statute, they call it the Rome Statute. Just go there. If some of you when you get a fast smartphone, you get an update on it, just go and Google. You say the Rome Statute of the RCC. When you Google it, you see it. You can download it, it will come in PDF. You look at it. It was passed in 2002, specifically by nations of the world. That Rome Statute is only applicable to people who violated international criminal law after 2002. From 2002, the date the crime was the act was passed, that law was passed. Onward, 2003, 2004 to present, all the way. Anyone who committed a crime from that period under the definition of the Rome Statute, that person can be prosecuted under the RCC. But if the person committed an international criminal court crime, that's an international human rights violation, and that act was committed below 2002, meaning in the 2000, in the 1990s, in the 1980s, in the 1970s, the Rome Statute is not applicable to them. The RCC is not applicable to them. What is applicable to them has to do with the United Nations Security Council resolution on the passage of international violations of law and Convention on International Human Rights. Those are the applicable international legal instruments that might be applied under that person. So you will never see they take them to the ICC. It is either the international, it is either the United Nations International Residual Mechanism. They call it the tribunal, or they call it the mechanism. The United Nations International Residual Mechanism for Criminal Tribunals. It is different from the RCC. That one is almost in many forms like the hybrid court in Europe countries, like the one you have in Sierra Leone. It's the same form of hybrid international instrument. Like the one you have in Rwanda, like the one you have in the former Yugoslavia. It is now referred to as they have transformed it into what we call the United Nations International Residual Mechanism for Criminal Tribunals and Courts, commonly called the mechanism. It has the same weight and standard of judges and lawyers that practice. There are lawyers that are qualified to practice before that court, and lawyers who are qualified also to practice before the RCC. So some of the lawyers are most are also qualified. They are admitted. They seek admission. They are admitted after passing through all of the screening. You pass your test. They admit you. So like I think we are only two here. Me and Sifos, only two lawyers here that are qualified before two different tribunals. Now, so if a person commits that crime under that particular arrangement during that period, it is not applicable under the Rome Statute of the RCC. So they won't arrest them under the RCC. They won't do that. They will not do that. I gave you an example with the Philippines. The former president of the Philippines declared the war on drugs. Unfortunately, under the former president, there were people in the security forces, specifically the police, According to them, the RCC, the prosecutor, the police had a unit that they identify certain people to be drug addicts and drug dealers. And then, as they identify them, they try to find a way that they can eliminate them. So when they go, they arrest you, they catch you, they take you somewhere, they say, let's carry them into the police station to another area. Then they fake the person's death. They follow that case at the RCC. They fake the death, and then they will kill the person. They kill so many thousands of people under the name of war on drugs. And I'd like to appreciate the DEA, the advice they give to the Liberian people. Let us be the one to arrest drug addicts. I'm just giving you a scenario. Now, the president of the Philippines was in a position to know, and certain officials, that indeed there was some rare execution of people for drugs who were not tried. Thousands of them. So as a consequence, thousands of people died. So the international community stepped in and started reviewing this case. Happened around the 2000 or around the 2015, I think 2015, 2016. Yes, after the court had been established in existence. So the former president, upon his travel out of the country, when he entered the Philippines at the airport, the international warrant was on him, arresting him for violation of international human rights, and violation under the RCC, the Rome Statute. So now they could not take him to the mechanism, the international residual mechanism. No. Because its jurisdiction does not extend to 2000 and above. The only court that has jurisdiction for this kind of crimes is the RCC, the International Criminal Court. They are very different. Don't let it fool you, but when you do your check, you know they are different. So it is the RCC that instituted that particular something. So that is why I'm just telling you some of these things, how they work. The next principle of criminal law is individual criminal responsibility. In other words, crimes are not transferable. For many of you who are the criminal justice students, you know exactly what I'm talking about. When they say crimes are not transferable, if Arthur Johnson has a friend that he spends most of the time where they are so friendly, and that friend committed a crime, Arthur Johnson cannot be responsible for the crime that man committed under the doctrine of guilt by association. No. Everybody is responsible for his or all criminal conduct. Crimes are not transferable. You can't hold John Brown accountable for the crime committed by Mary Paul. So the principle of individual criminal responsibility states that each individual must be personally accountable and responsible for his criminal act, not to transfer that particular criminal conduct responsibility to another person simply because that person is friendly or is a friend or related to that person, or they live in the same house. The only time you can arrest his friend is when you have evidence to show that his friend aided and abetted in the commission of the crime. In other words, it means that his friend helped him to commit the crime before and after. Sometimes we call it accessory before and after the crime. Let's stop there today. The 30 minutes is over. The next time we'll meet again. We'll continue next week Thursday. Thanks for coming. Go to the YouTube page and subscribe. Thanks for listening. We'd like to end this broadcast.